First District Court of Appeals is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning and welcome to the First District. We have one case on our docket this morning. It is Main Street Entertainment doing business as Potbellies versus Guardianship of Jacqueline Ann Faircloth. We've allocated 20 minutes per side. Counsel for appellant, you of course may reserve time for rebuttal. Keep a close eye on the clock. There's a time on there that you can see. There are also lights. I guess I don't see the lights right now, but there are green, yellow, and red typically on the clock, but might have to move for you to see it. But keep a close eye on your time. Counsel for appellant, are you ready to proceed?
I am, Your Honor.
Please do so.
May it please the court, Raul Cantero of White & Case on behalf of the appellant Main Street Entertainment. I'll be reserving 5 minutes for rebuttal, if the court pleases. And also just to let you know, I'm standing up, so if you don't see me later, it's because I'm sitting down. I didn't leave the room. Okay. We've argued 4 issues on appeal. This is an appeal from a civil judgment of $30 million against our client, Main Street Entertainment. And we've argued, number 1, that the alcohol defense, 768.36, should apply in this case. And number 2, that the comparative fault defense should apply even under 768.125. Then we've argued language of the verdict form that was incorrect and that we should have been granted a directed verdict. I'll probably be able to go only through the first 2 or 3 this morning. Just to let you know, if you reverse on issue 2, which is the comparative fault defense, you would necessarily reverse on issue 1. And that's because all parties agree that the reason why the alcohol defense, we call it, under .36 did not apply was because the judge held that this is an intentional tort and therefore comparative fault doesn't apply, and 768.36 only applies in comparative fault cases. So if this court holds that this is a comparative fault case, as we argue in issue 2, then issue 1 falls along with it. So because of that, I intend to, the order of the argument I intend to use is to argue first that this is a comparative fault case. But second, even if it's not, even if you affirm on comparative fault, that the alcohol defense still applies because the statute is written differently. Unless the court wants any other order, of course, I'll answer whatever question you want. As to comparative fault, before section 768.125, and I'll just call it .125, was enacted, the common law protected from liability vendors who sell alcohol to their patrons on the theory that it is the use and consumption of the alcohol that's the proximate cause of any injury, not the sale of the alcohol. In 1980, the legislature enacted 768.125, which codified that law, but created 2 exceptions. And the one that is applicable here is it says, except that a person who willfully and unlawfully sells or furnishes alcoholic beverages to a person who is not of lawful drinking age may become liable for injury or damage caused by or resulting from the intoxication of such minor or person. The court said, and plaintiff argued, that because the statute talks about willfully and unlawfully, therefore it's describing an intentional tort, and this is not a comparative fault case and would not let us put the plaintiff on the verdict form.
Well, counsel, if I could interrupt, I apologize. It seems to me the language of the statute, which says it must be willful and unlawful, it somehow, to me, it distinguishes it from the ordinary concept of negligence. And if that's the case, I mean, it seems like would be difficult for a jury to apportion fault between intentional conduct, or in this case, willful, unlawful conduct, and just ordinary negligence type of conduct. So how do you do a comparison when one of the parties has engaged in willful, unlawful conduct?
Well, the willful and unlawful act subjects the party to a negligence action. And that's what the Florida Supreme Court said in Ellis, and it's a negligence action. If I can analogize it to running a red light, if I willfully run a red light, I know that it's red, I'm going to go through the light anyway. That's a willful act, but it does not create a willful tort or an intentional tort. If I run into somebody, if I crash my vehicle after running the red light, it doesn't become an intentional tort. It is still negligence, even though my act of running the red light is willful.
So I'm struggling with that, counsel. If I intentionally run a red light, I mean, I willfully, unlawfully run a red light, and there's someone on the other side, and I run into them. How could that be anything other than an intentional tort?
Because, Your Honor, the Supreme Court has defined an intentional tort is when a person shows a deliberate intent to injure or engages in conduct which is substantially certain to result in injury or death.
I'm sorry to interrupt, but couldn't the legislature here, when they passed 125, have decided that, they've basically, the law is sort of safeguard purveyors of alcohol, but this is an exception where they said, no. If it's willful, unlawful conduct, we're not going to give you any shield. If you're a bar and you serve underage drinkers, and it's willful and intentional, willful and unlawful, why couldn't the legislature just say that's a different species of wrongful intentional conduct, and therefore there's liability?
Well, it says that the purveyor may become liable for injuries caused by or resulting from the intoxication. Didn't say shall become liable, it said may become liable. And the Florida Supreme Court has said that this creates a negligence cause of action. Now, the plaintiff has argued, well, that is dictum because they were describing that was a habitual drunkard case, which requires knowingly serving alcohol to a habitual drunkard. This is a willful and knowing and unlawful case. Well, in Case versus Newsom, a 2004 case from this court said that the word willful in this very statute requires knowing that the person was underage. And so it has essentially equated willful conduct with the knowing conduct in the same sentence in the same statute. So it cannot be that everybody agrees that if it's a habitual drunkard, the cases absolutely hold this is a negligent statute as to habitual drunkards. If you knowingly serve a habitual drunkard, it's negligence. Even the plaintiffs don't disagree with that. So you would have to hold that when it's a habitual drunkard, knowing is negligence, but when it's a minor or someone on unlawful drinking age, then willful, which equates to knowing, now becomes an intentional act in the same sentence of the same statute. And so you'd be creating an anomaly within the same statute.
Well, but the statute is an and, it's willful and unlawful. So in this case, there's no doubt, is there, that I thought there was a stipulation of some sort that Potbellies was allowing its underage bouncer to purchase large quantities of alcohol. There's a question about how much of it he drank versus his buddies. But there's no question that it was willful and unlawful, correct?
There isn't. We did concede that, but we didn't concede that there was negligence as a result of it. That's, that was the whole point of the trial and the case.
Well, how could there not be negligence? I don't understand. I mean, how could there not be? At least?
We would then be responsible if the bouncer in this case, as a result, became intoxicated and he created some injury to someone as a result of that intoxication.
Well,
yes.
Let me ask you this: what if Mr. Dwyer, after he had left Potbellies and driving his pickup truck, I guess it was 55 miles an hour in Pensacola, what if he ran into a tree and killed himself? Could that, and let's assume, just for the sake of the argument, that he was intoxicated. I mean, would Potbellies be able to say, well, yeah, we served him alcohol willfully and unlawfully, but we're not, we want to use his intoxication as a defense, or we want to use his intoxication as a defense, saying, like, we didn't cause it. He was intoxicated. He ran into the tree.
Well, that does present a different factual scenario, and the courts have held that the liability of the vendor is derivative That's in Okeechobee Erie versus Wild. And therefore, it may be that in that circumstance, because it's derivative liability, that you can't apportion it. But I need to point out there are a couple of cases they didn't hold in answer to your question, but they did describe a jury trial in which the plaintiff was the one suing, was the one who drank, a minor who drank, and the jury apportioned liability. There was the Tuttle versus Miami Dolphins case. It was a minor who purchased alcohol, and the jury assigned him 45% negligence. And then there was the Archbishop Coleman F. Carroll case, 2010 case from the 3rd DCA, where the minor was a high school student and went to a graduation party, and then got drunk and actually, I think, ran into a tree on the way home, and sued, among others, the owners and the hosts of the party, the archdiocese, the school, and the jury in that case apportioned 53% liability to the minor who was driving. So it does happen. Now, the caveat is, for example, Tuttle did not involve 0.36, and Archbishop Coleman Carroll didn't involve 0.125. And the appellate courts did not actually discuss whether that was appropriate or not, but it has happened before. But again, I understand that that's.
So I was just going to say, so what I hear you saying is that if he would have run into a tree under that illustration, that it would still be relevant if he ran into the tree because somebody else had run a red light and he had swerved to avoid. It would matter what caused him to run into the tree, is what I hear you saying. That it's not the end of the story isn't the sale by the vendor.
It matters under the plain language of the statute because it says that the intoxication has to cause or result in the damage or the injury. So even in this case, the jury was asked whether Dwyer's intoxication was resulted in the damage to the plaintiff. So I believe that that's always an issue. But Your Honor, if you don't agree with me, first, again, I think it would create an anomaly in the law because this court has already said that that willful equates to knowing, and the Florida Supreme Court has already said in terms of the habitual drunkard, which requires knowing, it is a negligent statute. And other courts have followed that. But even if you disagree, and even if you affirm on this, then we go to 768.36. And that statute talks about in any civil action. It's not limited to negligence type actions. It says in any civil actions, if a plaintiff was intoxicated and was more than 50% at fault, then for their injuries, then there is no liability. We wanted to invoke that statute and the trial court rejected it. And the only,
excuse me, are there any civil actions that don't require the plaintiff to be injured? Or do we just interpret injury very broadly? Because the statute does say at the time the plaintiff was injured, which possibly limits the amount of the types of civil actions that the statute could apply to.
Yeah, they don't, there's no cases really discussing that. But there's certainly cases, and I can think of scenarios where it's an intentional tort and it would still apply. For example, you have the case of the Heatherly case. And again, that did not involve 0.36. They sued under 768.125, but there was a statute, and if I'm remembering correctly, it's 776.085 paren 1. And that statute said that if the plaintiff was committing a forcible felony, then there is no, if the injuries were during the commission of a forcible felony, then there is no liability. So there are statutes that say even if it's an intentional tort, you can deny liability. And I can think of, for example, in a bar fight where the plaintiff was assaulted and sues the vendor, the tavern, saying, "You served me alcohol," but the plaintiff provoked the assault. Maybe the plaintiff assaulted first, but ended up on the losing side and sued. You can apply 768.36. So I think that when the legislature said in any action, it meant in any action. And just because it's in this chapter doesn't mean it applies only in negligence actions. In fact, we have the punitive damages statute is at 768.72 in the negligence chapter. Yet everybody in this room and your rooms can agree that that applies in any action. It's not limited to negligence actions. So I don't think you can interpret in any civil action to say only in a negligence action or only in actions where comparative fault applies. That's not what the court, that's not what the statute says.
Well, if I can add, under 768.36, it says a plaintiff may not recover any damages. So if this case were tried on your theory, your client would not have to pay any damages.
That's correct. However, it has to be if the jury would have to find that the plaintiff is more than 50% at fault for that to occur.
But that's not what 768.36 says.
I believe it does, Your Honor.
Okay, well,
Yes.
as a result, it was more than 50. I got you. Okay.
Yes, yes. You scared me there a second. I was ready. Yes, so the plaintiff has to be more than 50% at fault. So that's why even if 0.125 is a intentional tort as it relates to vendors and minors in this situation, I think that this statute would still apply.
Can I ask
Yes.
a question related to how the trial court, or why the trial court denied an instruction based on this defense? Basically, they said that, well, comparative fault doesn't apply because it's an intentional tort. And because there's no comparative fault, you can't make a comparison, and therefore 768.36 doesn't apply. So my question is, what if 768.81 didn't exist at all? Could 768.36 be applied? Could we use it if there was no statutory concept of comparative fault?
Absolutely. Absolutely. The jury would just be asked, since it's not comparative fault, the jury may be asked what's the percentage of negligence, and it has to be 50% for the statute to be invoked, or was the plaintiff more than 50% liable or responsible for the plaintiff's injuries?
So your view is that it doesn't rely in any way on the comparative fault statute?
Does not. I see that I have 3 minutes remaining for rebuttal, so I'll have to rest on my brief unless the court has any questions as to the verdict form or the directed verdict issue. I'll rest on my brief as to those.
Okay, thank you, Counselor. What I'll do is we took away a couple minutes of your time, justifiable with good questions. So we'll give you the full 5 minutes. We'll give 2 other minutes to Mr. Sales, so we'll have 22 minutes.
Okay, thank you very much.
Thank you, and good morning, Your Honors. David Sales for Catherine and John Faircloth, who are Jackie Faircloth's parents, and obviously their guardians as well. I want to begin by pointing out that the comparative fault statute is somewhat unusual in all of Florida statutes, in that it tells the court that the court has a job to do, and the job of the court is to analyze the substance of a cause of action to make a determination as to whether or not the comparative fault statute applies. That's easy in a case where the cause of action easily fits within one of the definitions of negligence, but it's a little bit different here, where no one can genuinely contend that this cause of action, whatever it is, and more on that in a moment, fits the statutory definition of negligence. But what we know, and the statute is fairly clear on this, is that it exists for 2 purposes, I would submit for today. One is to prevent an ingenious plaintiff's lawyer from labeling a cause of action something it's not. And the statute refers to this somewhat directly. For example, he can't call a medical negligence claim like they used to do in the old days, a breach of contract or a battery, and avoid the common law concept of no comparative fault applying. And obviously the common law concept that comparative fault doesn't apply to a breach of contract claim. And in response, as a slight aside to your question, Judge Winokur, in the trial court in here, Mr. Cantero and his clients contend that it admits no exception. And I point that out as a sort of a placeholder, because if they're right, I would submit that the statute doesn't make any sense, because we can all agree, I would hope, that it cannot apply, for example, to a breach of contract case where someone's damage, it results in some way, directly or indirectly, consistent with principles of proximate cause to intoxication. But getting back to where we are in this case, just as the statute prevents an ingenious plaintiff's lawyer from mislabeling a cause of action, it also prevents an ingenious defense lawyer from calling something negligence when it's not. And I think it's important to remember, one of you mentioned the stipulation, I think it was you, Judge Makar, in this case. I think it's important to remember the extraordinary nature of the stipulation, because it relates directly to the very high degree of fault, I would submit a high degree of moral fault, that we have to prove in a case like this in order to prevail. It's something clearly more than mere negligence. And I agree with Mr. Cantero that if you find against the plaintiffs on this question, then our arguments as to the alcohol defense statute also fall away as well. Because as was suggested, and I'm not suggesting you're in agreement with us, Judge Winokur, but as suggested by your earlier question, there obviously is some relationship between the two statutes. But getting back to the stipulation, I'd like to read it to remind the court, because I think it's important. Potbellies knew that Devin Dwyer was a minor and not of lawful drinking age. Potbellies had actual knowledge of Devin Dwyer's age, and notwithstanding same, willfully and unlawfully furnished alcoholic beverages to him on the night in question. One of the things that's easy to overlook about this case is because that was a stipulation. It's not like the typical negligence case where someone might agree and concede negligence. That's an extraordinary event in a case like this, because it limited our burden of proof to proving intoxication and a causal relationship. But when we get back to the issue of whether or not this is an intentional tort, the facts do matter, because this is not a mere moment of inadvertence. This was, if you look at the facts, certainly in the light most favorable to us, this is the business model of this bar. We have another co-employee, underage, drinking, purchasing alcohol at half price, intoxicated. We have someone who, it's undisputed, was a freshman there, 19 years old, being served and intoxicated. This is what this bar does. And
Well,
it
counsel,
is not.
counsel,
Yes, sorry, Your Honor, go ahead.
You don't have to spend time on that. We have an amicus brief that tells us how serious the alcohol problem among
Right.
the university community is in Tallahassee, and that's why FSU filed a brief in this case.
Right. I reference it really more directly, Your Honor, to point out the facts support the theory of the plaintiff's suggested application of the statute, that this is a business model of the bar, and that it is something which connotes a high degree of moral fault when Your Honors go about the task of making a decision about what the substance of this cause of action. It is simply stated something more than mere negligence.
Well, let me ask you that, counsel. As I look at the statute, I'm looking at 125. It seems to me what the legislature has done is carved out an area of particularly opprobrious behavior, meaning it's just not ordinarily negligence. I mean, there's all kinds of defenses in the criminal statute. Well, the person looked to be of age, or the person had an idea that looked legitimate, and so forth. They haven't done that with 125. What they've done, it seems to be, and tell me, I assume this is your view, is that they've carved out an area of conduct that's particularly pernicious to make it a tort liability issue.
I agree exactly with Your Honor, and getting back to the history here, Mr. Cantero is right. There was a common law, no cause of action at all. And what happened, and Ellis speaks to that, is that there was a little bit of an erosion among the DCAs in picking apart the rule that prohibited all claims sounding in negligence or something else. And the legislature came forward and said, look, we're going to allow lawsuits in 2 instances, and they're not the same. I mean, there's no basis upon which they can be argued that they're the same. And Ellis actually says that. Knowingly has to be something less. And I heard what Mr. Cantero said about that today, but it has to be something less than willfully and unlawfully. And I agree with Your Honor. We're criticized in our brief for suggesting that the court consult Black's Law Dictionary to see just how bad this is. And what we find in response is that the cases actually tell us that that's one of the things that Your Honors is supposed to do. And Judge Makar, it's true. There are other criminal statutes and other statutes from the past that use this or similar expressions. And when we look at the cases that tell us what the courts have decided that word means, it means at least intentional misconduct. And they don't have any really, yeah, sorry, Your Honor.
I mean, the legislature included a number of defenses in 562.11, but they didn't put any of those defenses in 768.125. Is that sort of the point? Is that they've singled out?
I agree with that, and I disagree with the defendant in this case, where they suggest that there's a relationship between the 2 statutes. It is true, as we know now from looking at the cases, that this statute was supposed to be not in the negligence chapter, but in the beverage enforcement chapter. But the statute did not incorporate the defenses that were available. You do have to, in order to violate one of the statutes, I think it's 562.11, just commit the act of service, and the mental status, the mental state, the mens rea, as we say in our brief, of the defendant in that context wouldn't matter at all. Here they have to do something much worse, and it makes sense if you think about what the legislature was trying to accomplish, to arrive at a compromise which would preserve the common law. The trial court picked up on that. Ellis teaches that, while at the same time allowing for a very high degree of moral fault, a lawsuit. And that's the lawsuit that we have here. And picking up on something that they said in their initial brief, and Mr. Cantero has repeated that today, that you should look at the dictum in Ellis to know that, in fact, that this is a negligence cause of action. I just urge the court, I think we've mentioned it in our brief, but to take a look at the Austin case, which this court cited with approval in McDonald. And interestingly enough, that part of McDonald was actually approved by the Supreme Court of Merrill Crossings, at least. And I acknowledge that in McDonald, as we say in our brief, it's dictum. But there is not here just something that was knowing. And the Tuttle case that Mr. Cantero referred to, what that case really stands for, and this court's case decision actually stand for, is the proposition that if a plaintiff cannot minimally prove knowledge, then they can't meet the much higher bar of willful and unlawful misconduct. I think that's the real point of these cases. But if you take a look at the Austin case, again, which this court cited with approval, it says, counsel for plaintiff herein has seized on the erroneous Ellis dictum as a basis to claim that a negligence cause of action still exists in Florida. And that can't be so. The main reason is that Ellis itself draws the distinction between knowing and willful and unlawful conduct, and points out that that was purposely done by the legislature. For those reasons, we really urge the court to do what the statute tells the court it should be doing, which is to examine the substance of this particular claim. And the substance of this claim, as your questions perhaps suggest, Judge Makar, is to identify a high degree of moral fault and find, in fact, that this is an intentional tort. If it is an intentional tort, if it is an intentional tort, our position is based on a matter first of plain language. The comparative fault statute, the part of the comparative fault regime that regulates the conduct of intoxicated claimants cannot apply. It is not adequately accounted for in the defendant's brief or in argument today. The fact that that sub 768.36 subsection 2, if we were, for example, to diagram this as a sentence, reading it without all of the stuff in the middle, it says a plaintiff in any civil action may not recover damages if at the trier of fact finds at the time the plaintiff was injured the plaintiff was more than 50% at fault for causing his or her own harm. I don't think the defendant has a good explanation for why the court should read that word out of the statute. It's there and it has to mean something. And it means two things, I would submit. One is a matter of plain language. It doesn't apply in a circumstance where there's an intentional tort because there is no comparative fault defense to be had. But also, if the court is not persuaded that that is the right construction as a matter of plain language, the court should adopt that construction anyway, because it wouldn't make any sense. And this issue about intentional misconduct and there being a defense based on intoxication has two important parts. One is suggested, and I believe most respectfully that the key to understanding this case is to understand that there are, in fact, no differences between the kind of case that we have here, what I'll call a third party case, where the intoxicated minor causes harm to a third party, and the other kind of case, which we brought simultaneously, which I'll call a first party case, where an intoxicated minor is injured as a result of her own intoxication. What we know from the cases, starting with Migliore, that's the Supreme Court's decision in 1984, and there are a number of them cited in our brief, it doesn't make any difference. It doesn't make any difference whether or not it is a first party case or a third party case, because the legislature has decided that when there is that very high degree of moral fault that's met, and we have met our burden by stipulation in this case, then it doesn't matter where the ultimate consequences and ultimate harm fall. And that is why this is an intentional tort for another reason, because we know that the legislature views the service of alcohol in and of itself as something that is injurious. And there is no question about that. But the other point,
It sounds to
Yeah,
me like,
sorry, Your Honor.
I'm sorry, it sounds
go
like
ahead.
the thing is that every time there is negligence per se because of a violation of a statute, maybe a criminal statute, then it's necessarily intentional because it was wrongful conduct. After all, it violated a statute, and therefore it's intentional. Whereas what I understand, at least the appellant's argument to be, is that the intent is not the intentional act, which in this case is selling alcohol, but that you intend the injury, you intend the harm. That's the hallmark of an intentional tort. If it weren't, then I don't understand why any type of negligence per se, where you can prove wrongfulness of the act, would constitute an intentional tort. Or is that your argument?
No, I think there are two parts to that. One, which they really don't have any response to, and one which I was just alluding to a moment ago. If you could conceptualize this for a moment as a statute which prohibited pharmacies from selling prescription drugs, same words, except it was pharmacy and prescription drugs. Would any of us be having an argument about whether or not from the time that the prescription drug was sold to Dwyer and Dwyer consumed it, that there was an injury that had already taken place and that it was intentional, an intentional tort causing injury? I think one of the reasons we don't necessarily look at it that way when we think about the alcohol statute is because of the pervasiveness of youth consumption. But the legislature's judgment is that no alcohol should be consumed by minors. And I submit that this falls exactly within the kind of concept of an intentional tort, because when Dwyer was served, as we say in our brief, there was already a kind of injury that had taken place. Nobody doubts and nobody questions that he drank at least some alcohol, and the jury found enough to become intoxicated. But I think the other part about that, Your Honor, is that, as we point out in our brief, in the common law concept, when there is an intentional tort, even if the ultimate harm is visited upon somebody else, that does not allow the intentional tortfeasor to escape liability. If I swing at A with intent to harm A, and A ducks and miss, and I strike B instead, I am still liable for intentional torts just as much as I would have been if I had struck A instead. And here, Dwyer was, as we have all acknowledged, I think today, one of the persons who was within the category of those that the statute is designed to protect. And in additional response to your question, Your Honor, Judge Winokur, I don't agree that this statute, if you read it the way that we suggest, that means that every criminal statute, for example, results in a valid negligence per se claim. We have a special civil statute here with a very high degree of moral fault, as I say, and that is something that is very different. The other tests for the presence of a negligence per se claim would have to be available in order to make the claim that there was negligence per se. And interestingly, the case is out of my head for the moment. One of the courts has indicated that as of this point in time, as a result of the existence of 768.125, there is no longer a negligence per se claim based on the violations of Chapter 562. So those are my responses to that question, Your Honor.
Counselor, if I can interject a question, I don't see where in the trial judge's order, the order granting the motion for partial summary judgment, Judge Carroll, to an 8-9 page order, I don't see where anywhere in there he mentioned 768.36. Was
Right,
that?
right. That was sort of, I guess, the building blocks of this, and we've sort of constructed the same way. What happened, and you may recall that the case was mistried, and then when the parties argued those legal issues about the application of the statute during the first trial, I think it actually took place during a charge conference, and the pages of the record for that, I believe, are cited in our brief. And the parties had, I would submit, a fulsome argument about whether or not the alcohol defense statute could apply. And Judge Carroll did state his reasoning on the record there. He says the whole statute 768.36 deals with comparative fault, picking up, I think, on what our arguments are here today, and the arguments were certainly made by trial counsel, that because it is part of the system that regulates comparative fault, going back to one of the earlier questions today, that it could not apply. If you don't have comparative fault, there is nothing to compare it to. And I think that is, in fact, in the record. You'll see, again, those citations to Judge Carroll's thought processes in the brief. But it is correct that he didn't rule on that at the time. That ruling came later.
Okay, so is there another document where he addresses 768.36, or was it just in the charge conference for the conference?
It is in the transcript, and those page citations, which I have cited in the brief, appear in the record. To leave my remarks on this case, what I would ask the court and my opponent as well, if I were permitted to ask him a question, is if they really contend that the alcohol defense statute applies to a claim of battery. The example was given earlier this morning about, in one of your Honor's questions, about whether or not if Dwyer had hit a tree, would there be a comparative fault defense? And I would submit it's equally appropriate to ask, would there be an alcohol defense? And there is no way to do that, I submit most respectfully, and to have these statutes make sense. The alcohol defense statute, just as an example, is in the nature of a contributory fault law. It sort of restores, if the comparative fault is met at 50%, it restores the doctrine of contributory fault as the claimant. But we know at common law that contributory fault and later comparative fault, before the comparative fault statute was adopted, both of them, contributory fault included, did not apply when there was an intentional tort. And that's why this is the key to the case. If the court decides that it's an intentional tort, these doctrines cannot and should not apply. But to use the example of Dwyer hitting the tree, if we were here on the claim of Dwyer against the bar, the arguments would be the same. And I go back to what I said just a few moments ago. The key to understanding this case is to understand that the statute admits no difference. There is no difference between the kind of case that we have here, what I'm referring to as a third-party case against Potbellies, and a first-party case if Dwyer had been the claimant. And imagine, if you will, if he had been the claimant, and we were here, the counsel were arguing that not only that his comparative fault was an issue to be decided by this jury, but also arguing that the jury should have decided whether his intoxication, the key element in terms of his own conduct, was something that would give rise to a comparative fault defense, and effectively a contributory fault defense, if he were 50% or more responsible for the outcome. That is to say, in proving a case based on his own intoxication would amount to a defense on a sort of a sliding scale, up to the point of 50%, where he would be out of court suing when the legislature had provided means for him to protect him against his own intoxication. That would be respectfully an absurd result. And the last thing I want to say is there's a lot of talk about his negligence. There is no case that's cited by any party that suggests that it matters whether or not Dwyer had acted negligently, intentionally, or without any kind of mens rea. And to give another example, it is not impossible for someone to be intoxicated and to form an intent to harm another. That's something that could probably describe a lot of our fights. It wouldn't make any difference if he had acted intentionally as the law defines it. It wouldn't have made any difference if he had fallen down while walking outside the bar, not acting negligently, not acting intentionally, but had just simply fallen as a result of proximate cause. And again, in conclusion, that's the key to understanding the statute, is that it has two important parts. One, the willful and unlawful part that we've been talking about, and the second part, which is what I've sort of referred to as a two-tiered causation element in the past. If intoxication results and there is a further result of an injury, there's liability. On behalf of the plaintiffs, we urge the court to affirm the trial court's judgment. Thank you very much.
Thank you, Counselor. Okay, please proceed.
Thank you, Your Honor. Mr. Sales began the argument by talking about certain absurd results that could apply here if, for example, there was a breach of contract action and we asserted this defense of 0.36. The fact that there may be an absurd result in a particular case doesn't mean that it would be an absurd result in every case. Courts all the time interpret statutes and they say, well, to apply it in a breach of contract action like this one would be an absurd result. The question is whether it would be an absurd result to apply it here, and I submit that it would not be. As far as knowing versus willful, this court in case, and I will quote this court's language on page 1153 of Case versus Newman. It says, a willful sale or furnishing of alcoholic beverages to a person not of lawful drinking age requires knowledge that the recipient is not of lawful drinking age, which may be proved by direct evidence of actual or such knowledge as may be established by circumstantial evidence. So Case versus Newman equated willful with knowledge. And the statute also says if you have knowledge that there's a habitual drunkard and serves them, then you're liable for that. In Ellis, the Supreme Court applied that to knowing to habitual drunkards and said that's a negligence action. And not only that, it specifically described as to alcohol to minors as a negligence action. On page,
Counsel, isn't willful higher than knowing? I mean, you can know something, but then act willful.
You would think so, but in terms of, serving alcohol to someone of not of lawful age, what can that mean except you knew the person was not of drinking age and you served anyway? It may be a distinction between knowing or should have known and actually knowing it. If you actually know it, then it's willful versus you can be imputed if it's known or should have known. In Ellis, the court summarized all the cases from the Supreme Court that Mr. Sales described, like the Bankston case, McGlory case, other cases on page 1046 to 1047 of its opinion. And then it said, in summary, the above case law has established that, although limited by the provisions of section 768.125, there is a cause of action against a vendor for the negligent sale of alcoholic beverages to a minor that results in injury to or death of the minor or a third party, specifically talked in terms of negligence. So if this court says that, no, it's not negligence, it's an intentional tort, then I submit and I request that you at least certify a question to the Supreme Court and say, look, did you really mean what you said in Ellis? Because Ellis didn't actually concern a minor, it concerned a habitual drunkard. And that's why Publix says, well, that's dictum. Well, that statement in Publix was dictum itself, because Publix said this should have been remanded for directed verdict and didn't apply that. So There's dictum all over the place here. But in terms of which dictum is more persuasive, I suggest that it's the Florida Supreme Court's dictum in Ellis that's more persuasive than dictum from another DCA, especially when you combine it with a holding in Case versus Newman from this court saying that willful means knowledge, and knowledge is a negligence act in terms of habitual drunkards. So how can it not be in terms of underage drinkers? Section 768.36 was designed, remember, it was enacted as part of a comprehensive reform of Chapter 768 in 1999. It's the Chapter 1999-225, which amended several provisions in Chapter 768 and created 768.36, 19 years after the 768.125 was enacted in 80-37, because the legislature wanted to impose some responsibility on the actual drinkers of the alcohol, not just on vendors, not just on those who provide it, but say, look, if you have drunk to the extent that you're more than 50% at fault, you should bear some responsibility for that as well. Otherwise, what's the point of that statute? I see my time has run out, so I appreciate your patience. I appreciate the extra time, Your Honor, and I ask that you reverse and remand for a new trial. Thank you very much.
Thank you both for your advocacy. The case is now submitted and we will be in recess.
Thank you.